In this lecture, we look at the rights and responsibilities of U.S. citizens. Citizenship is a broad topic, and we can't possibly cover all of it in the next few minutes. But what I would like to do is talk about some of the rights and responsibilities of United States citizens. The first question to ask is, does U.S. citizenship matter? In one of our earlier lectures, we saw that some persons who are lawful permanent residents, green card holders who may stay in the United States indefinitely, choose not to become U.S. citizens even though they could do so. So we might come at this question from that perspective. Why naturalize? What benefits would you gain by becoming a United States citizen? Here are some of them. The right to vote and serve on juries is one of the most basic rights of United States citizens. It's a right to participate in the political process. And when we put in perspective the approximately 11 million undocumented aliens who are living in the United States, along with legal immigrants, that's a very large part of the population of the United States, relatively speaking, who do not participate in the political process. Also, a right to serve in federal and most state elected offices. Perhaps the most important, and since 9/11 may very well be the most important, is that citizens, United States citizens, cannot be deported or involuntarily expatriated. This is a very important right. We did note earlier that fraud in obtaining naturalization, perhaps with fraudulent documents, could result in revocation of that citizenship, but other than that, with United States citizenship, you are guaranteed protection against deportation. In fact, though, guaranteed is the wrong word to use. As we will talk about in the next lecture, there have been instances in which United States citizens have been mistakenly deported because they could not prove their citizenship. We will talk about proof of citizenship in the next lecture, but it might be instructive at this point to give you an illustration. Very recently, the Immigration and Customs Enforcement Agency, also known as ICE, detained a woman on the ground that she was not a United States citizen when in fact she had been born in Texas. The family provided all of the evidence to ICE, including a birth certificate, but ICE contended that those documents were fraudulent. A lawyer got involved and was able to produce hospital records as well as, once again, producing the birth certificate. Nonetheless, this woman was detained for 3 weeks and very nearly deported because she had been unable to convince ICE agents of her citizenship. The agents apologized for the 3-week detention, but claimed they didn't believe her because she spoke very little English and she, quote, seemed foreign. Again, we will explore these very important matters of how you would secure and prove your United States citizenship. But this anecdote illustrates the importance of United States citizenship as at least a theoretical protection against deportation. Continuing on the topic, does U.S. citizenship matter? What are some of the rights that come with it? For lawful permanent residents, if they naturalize and become United States citizens, then it becomes much easier for family reunification. They receive family reunification preferences in immigration law. Lastly, United States citizenship matters for certain social benefits. Lawful permanent residents are eligible for some benefits after 5 to 10 years from the date of naturalization. But as a general rule, non-citizens and certainly undocumented aliens are not entitled to many of the state and federal benefits that U.S. citizens receive. Let's look at this question more closely by considering the Welfare Reform Act of 1996. Undocumented aliens and temporary visitors, such as tourists, student visa holders, and so forth, have for a long time been ineligible for federal and state welfare assistance. And until 1996, there was no federal benefit program that denied eligibility to permanent resident aliens, the LPRs, green card holders. But then in 1996, non-citizens now became ineligible for supplementary security income, that's SSI, and food stamps. They have to become citizens for those. These are just illustrations of some of the ineligibilities that rely on citizenship. Furthermore, Green card holders are also barred from other federal benefits for the first 5 years of their residence in the United States. My slide here also notes see state laws related to immigration. There are a wide variety of exclusions of various kinds enacted recently by states with respect to eligibility for benefits for non-citizens. We don't cover those here, but they are increasingly important in the daily life of non-citizens in the United States. Well, if there are rights, then there are also some responsibilities. And just talking about a few of those are the most important. Traditionally, military service by nations is considered a right and a responsibility, a right of the nation to require it, a responsibility of the citizen or subject to supply it. Allegiance, that's the opposite of treason. Allegiance to the government is also a responsibility that one has. And here you might consider comparing the oath of allegiance that's required for naturalized U.S. citizens. We looked at that oath of allegiance in Lecture 1. Most responsibilities, though, apply to all persons within the United States, regardless of citizenship. All persons must obey the laws, must obey the criminal laws, pay taxes, and so forth. So many of these responsibilities are not unique to citizens, at least at the current time within the United States. So many of these responsibilities are not unique to U.S. citizens. We will discuss rights of non-citizens in future lectures. A brief reminder of citizenship in the U.S. Constitution, because it relates to this issue, that many responsibilities and rights are shared by non-citizens in the United States, and that comes from the 14th Amendment. So let's take a look at that language again briefly. The first sentence we know is what establishes birthright citizenship. Beginning with the highlighted part, no state shall make or enforce any law which shall abridge the privileges or immunities of citizens of the United States. So that part is restricted to citizens. What are the privileges or immunities of citizens of the United States? The Supreme Court has basically said there are very few that are not reflected elsewhere. And these few are basically a right to travel between states. Look at the Due Process and Equal Protection Clause below that, as we've done before. Nor shall any state deprive any person of life, liberty, or property without due process of law. So due process does not depend upon citizenship if you are within the United States. Also, the Equal Protection Clause, which concludes Section 1 of the 14th Amendment, nor deny to any person within its jurisdiction the equal protection of the laws. So equal protection, likewise, is not dependent upon one's citizenship. I want to turn now to a brief look at citizenship as a matter of international law. One of the first documents we need to consider is the Universal Declaration of Human Rights in 1948, which followed the upheaval of World War II. Article 15 of that declaration affirms that everyone has the right to a nationality, and no one shall be arbitrarily deprived of his nationality, nor denied the right to change his or her nationality. Membership in a nation is fundamental to protection under international law. Every modern state formally defines its citizenry and attaches certain rights and responsibilities to that status. Access to citizenship may be restricted, just like it is in the United States. Another aspect of international law that we should consider is the Convention on the Reduction of Statelessness. The United States has signed this treaty but has not ratified it. Let's look at some of its provisions. States have absolute sovereignty to confer their nationality on any person for any reason. And because this convention or treaty is addressing the concept of statelessness, let's think about that for a minute. We will talk in a future lecture about dual nationality, but there's also the possibility that a person will have no nationality and thus would be stateless. No nation considers that person to be a citizen. So the Convention on the Reduction of Statelessness provides that otherwise stateless persons may take the nationality of the place of their birth or of the place where they were found, in the case of a foundling, or they may take the nationality of one of their parents, in each case possibly subject to a qualifying period of residence in that state. What this is providing is that primarily one's citizenship should be determined for stateless persons by birth within the territory, which would be a jus soli rule. But it also gives them the option of taking the nationality of one of their parents, which is an illustration of the jus sanguinis. The United States, as I mentioned, has signed but not ratified the treaty. The stated reason against ratification is that the treaty itself allows renunciation of citizenship at will, even if there is no other nation to claim that person. In other words, under the statelessness doctrine, it would be possible to renounce citizenship to make oneself stateless, and the United States objects to that practice.
The preceding program is copyrighted by Emory University.